I'm Jim Grismer, Professor and Dean Emeritus at the University of Denver. Welcome to Engaging Ideas, where we bring information and ideas from the Academy to the community to help think about real-world questions. Today we're going to look at our third co-equal branch of government, the judiciary, specifically our state judicial systems. There's little doubt that judicial independence and public trust in judicial systems is essential to society and to our democracy. So the essential question is, what can be done to strengthen trust in judicial systems across the country? The University of Denver's Institute for the Advancement of the American Legal System has some interesting ideas on this topic. Joining me to discuss the matter is retired Colorado Supreme Court Justice Rebecca Love Corliss, Executive Director of the Institute for the Advancement of the American Legal System. So let's begin. Welcome.
Thank you, Jim.
Rebecca Corliss, let me begin by asking you to give us an overview of this topic and why it's important.
Public trust in the judiciary is central to its legitimacy, to its capacity to enforce its orders. If you remember, it has no military or police force at its beck and call and has no power of the purse at its beck and call. So it relies entirely upon trust and confidence. As we look at how to protect trust and confidence, part of what we find is that people care a lot about how judges are selected and the process they go through in order to get on the bench.
So let me delve into this just a little bit more. Can you talk a little bit about the issue of effectiveness and accountability in the judicial branch?
Sure. Let me back up a minute and remind all of us that we're talking at the moment about state court judges. Mm-hmm. Federal court judges are selected by a process that is driven by the United States Constitution and has its own ebb and flow, parts of which are great and parts of which aren't. But we're talking now about that which is closer to home, namely the selection of state judges and justices. Okay. In 22 states around the country, Supreme Court justices are selected in contested partisan elections. What that means is they're out on the hustings raising money, they're promulgating ads that both tout themselves and decry their opponents, and they're affiliating with a political party and prejudging issues that may come in front of them.
So it would be very similar to a person running for state legislative office.
Precisely.
Okay.
And we worry about that because judges are not politicians in robes, nor should they be perceived as being politicians in robes. They're accountable to the Constitution, the law of the land. They're not accountable to a particular constituency.
So if we want to maintain the effectiveness and accountability of the judicial branch, what can be done? What approaches exist?
Absolutely, and we at ILES have thought a lot about that and done a lot of research on it. We first acknowledge that there is a tension between accountability and independence. The federal judiciary, for example, the U.S. Constitution has tilted that balance in favor of independence, and there's very little accountability. Those judges are appointed for life and justices of the United States Supreme Court. States around the country don't buy into that. They balance accountability and independence differently, but the proposal that we have, which is in place in a number of states, is something that we call the O'Connor Judicial Selection Plan, which is, in our view, the right balance between accountability and independence.
So what are the key elements of that? What does it look like?
There are 4 key elements, the first of which is a nominating commission. That nominating commission is comprised of a balanced group of people chosen by different appointing authorities who have different political backgrounds and who hopefully also comprise a number of lay people. So it isn't just lawyers doing the choosing, because there's a significant portion of the citizenry beyond lawyers who are influenced by judicial decisions. So the nominating commission takes applications for any particular vacancy, screens them, interviews candidates, and then tees up a group of nominees to the governor. The governor, so that's phase one. That's the nominating commission phase.
And this would be nonpartisan in the sense there's no labels associated.
There are no labels associated with any portion of it. And interestingly and anecdotally, part of my role on the Colorado Supreme Court was to serve as an ex officio chair of nominating commissions around the state. And I probably did somewhere over 20 of them. Only once did I hear a nominating commission hone in on the applicant's partisan affiliation. Otherwise, they were entirely focused on the attributes necessary for a judge before whom they would be comfortable appearing, the kinds of things you want them to be thinking about.
Exactly.
So phase two is gubernatorial appointment from that list. And again, the governor has the opportunity to interview, solicit information from a number of people who have worked with those applicants, and then he or she makes the final choice.
But they're choosing from this body of applicants.
They are limited to that particular list. And that's important because it constrains the gubernatorial impact here and the politics that can come into play from that branch. The third step is something that is called judicial performance evaluation. And although Colorado is one of the leaders in that front, my suspicion is that there are a significant number of viewers who will be listening to this who say, judicial what? And it's a job performance evaluation process that is conducted through surveys distributed to people who have appeared before or worked with that judge, then collated by a judicial performance evaluation commission and published for the benefit of the voters.
Now, this is different than comments from the bar, for example. This is a separate process.
This is not a bar poll.
Yeah.
And those have actually been referred to as beauty contests because it has to do to some extent with the judge's popularity.
Sure.
This is not that at all. This is people who either are working closely with that judge or who have appeared before that judge as a litigant or an attorney, or other judges who perhaps review that judge's work. So it's a broad swath of people who ought to have pretty good information about whether that judge is doing his or her job.
So you've mentioned three components, I think. Does that constitute the sort of approach?
Well, the most important component when you're talking about accountability is the retention election. So now, armed with the judicial performance evaluation information about that judge, the voters have an opportunity to determine whether the judge continues to hold his or her seat or is voted out. So it's called retention election because there is no opponent. And the question is, are you going to retain this judge in office or not? And that vote is then usually at the bottom of the ballot for Colorado voters, but they have a say. They have an opportunity to have a way of holding that judge accountable for the things that he or she thinks are important.
And it strikes me that that decision is heavily influenced by the ability to get the information to the public. How is that done? Is it, in your judgment, done well? Could it or should it be improved?
The judicial performance evaluation commissions in the states that have this program struggle with that. Voter attention around an election is usually focused on the much higher profile elections and the ones that are paraded in front of them by way of ads. not on judicial seats. Judicial performance evaluation commissions try to get the word out. We at ISLES have tried to help them. We've come up with a series of recommendations for some marketing approaches, social media approaches, even some ads that they can consider using in order to get a little more public interest in the process. But the ultimate objective is an informed electorate, as in every other election.
Right.
And that's tough. The voters have to really commit themselves to looking at the recommendations that the performance commissions have made, and to the extent they have the time and will, digging back into the data.
And I think it's easy to forget that these decisions, these retention decisions for judges, are just as important as the higher visibility positions. It's a separate branch and making very important individual and sometimes public policy implications.
Exactly.
Yep.
And I always think about it in terms of, as I said a little earlier, the kind of person you would want on the bench if it was your case.
Mm-hmm.
Whether it's anything from a traffic ticket to a contract dispute, a divorce, an opportunity that you might have to contest a policy issue.
Right.
You want someone on the bench who's impartial, who's intelligent, and who has a very high level of integrity. And those are the criteria that we suggest people look at when they're trying to figure out if they support a judge.
Now the O'Connor plan, which you've just described, the 4 elements, is there any evidence that this actually produces better outcomes? It sounds good, but do we have any evidence that it actually produces better results?
There are 3 facts that I would point you to that I think support better results. One of which is that in national polls, there is an indication that 9 out of 10 people believe that if a justice receives money in a contested election from a business interest, that he or she is more likely to vote in favor of that business interest. Mm-hmm. So there's an immediate appearance of bias.
Right.
Number 2, judges who are elected, as distinguished from those chosen through this system we're talking about, are much more likely to be disciplined, and when they are disciplined more severely.
So statistically,
Statistically so. And number 3, people of color are more likely to rise to a judicial position in a process that uses the O'Connor selection method than in an elective process. So all 3 of those I would offer up as indication that this is indeed a better way of going about it.
Now we're talking about state governments, and can you give us a sort of a cross section? Are many states following the O'Connor plan? Where is the preponderance? Is it in partisan elections or nonpartisan approaches, such as you indicated?
The preponderance is still in partisan contested elections, particularly when we're talking about state Supreme Court justices. Once you get down into lower levels of the judiciary, states tend to branch out and have some portions of their judiciary that are appointed through a merit selection process and some portion that are elected. There are only 7 states that follow the O'Connor plan for all of their judges. And in those, Colorado is actually one of the leaders on the judicial performance evaluation front. Those states tend to be, interestingly enough, Rocky Mountain West and
really?
Western states. So I don't know what that tells you about the balance between accountability and independence, but I would argue with you that it says good things.
So you indicate that Colorado is a leader in this area. Can you give us a perspective on how that's evolved and where you think it might go in our state of Colorado?
Judicial performance evaluation started in Colorado in 1987 without being overly transparent about my age. I was one of the first judges in the judicial performance evaluation process when I was a trial court judge.
A teenage judge.
A teenage judge,
Yes.
No question about that. It was most recently reauthorized by the Colorado State Legislature last year and improved in the process. Where it's going is an effort to publicize the data more thoroughly and in a way that's more digestible for the public, to include self-represented litigants in a more fulsome way. And what that means, there's a phenomenon in the state courts, which all by itself is very troubling, which is that more and more litigants are representing themselves. They do not have lawyers for their cases. In family law cases, for example, it's 80% of the litigants who do not have lawyers. Those people need to have a process for reporting out their views of the judges before whom they appear. Historically, the surveys have gone primarily to lawyers and not to litigants themselves. So judicial performance evaluation programs are starting to try to morph and figure out how to include those people and their opinions in a systematic and fair way as well. And then a little more dedication of resources so that the programs can work effectively and in a thorough way. Colorado has looked for a while at doing evaluations of judges between elections, just for the benefit of the judge. And we're going to start looking at whether we can afford to do that again. And speaking from a former judge's perspective, people don't criticize you, even if they don't think you're doing a very good job. You don't have many lawyers who will sidle up to you and say, boy, I really wish you would do this differently or that differently. They're likely to be very applauding of your work, whether they think that or not. And so a way of getting really objective feedback along the way and early in a judge's tenure is a really good thing for self-improvement.
So we talked about the evolution of this approach, this merit-based approach in Colorado. What's the landscape look like nationally? What are the trends across the nation?
The trends across the nation are not great. There's a great deal of distrust of the judiciary, concern about whether judges do have political agendas, and legislatures are moving toward trying to constrain the judicial branch rather than looking at different ways to seat them in the first place that will sort of sever political ties in an appropriate way. So we're seeing what we call possible court curbing legislation, which is an effort to constrain the jurisdiction of courts. For example, to have an act that prohibits judges from ruling on school financing issues, or to consider a piece of legislation that would hold that the court cannot hold acts of the legislature unconstitutional, which creates some constitutional crises from our perspective, but that seems to be the direction. There are 3 states that are starting to get serious about looking at a switch from elected judges to merit-selected judges, and we are applauding those states and trying to supply them with research and other information that may be useful to them. My hope is that there will be a swinging of the pendulum where people remember how important it is to have an impartial judiciary that they can trust, and not to sweep them into the same bin with the elected branches of government. I mean, sometimes I have trouble wrapping my head around the fact that people would say that the legislative and executive branches are working so well that we ought to try to make the judicial branch look just like them. I don't think so. So retaining that impartiality, independence, integrity of the judicial branch, I think in this day and age is more critical than perhaps it's ever been.
And correct me if I'm wrong, but it seems to me that there's an implicit connection between the merit selection and the continued independence of the judiciary itself. Is that, in your view, accurate and something that you're trying to foster?
Absolutely. And let me give you one very brief anecdote. There are some states that have both elected and appointed judges. I was at a conference where judges were on a panel, some of whom were elected and some of whom were merit selected. And they were talking about how they make decisions. And the elected judge said, well, I always think about what it's going to do to my reelection and what my party would think of the particular order that I'm issuing or opinion that I'm reaching. So if you want to protect independence and integrity, you have to have systems like the O'Connor Judicial Selection Plan. And in our view, that is in fact the best balance between protecting that independence, but also giving the voters a voice.
Finally, this is a very important subject, and as you think about it, the public engagement in this is really important. And what are some key points, some questions that you would offer for people to think about and ask themselves, or to discuss with neighbors and others about this basic question of judicial selection and the independence of our judicial branch?
I would invite people to think about the history of our country and the points at which independent courts have made a significant difference in the course of society. Brown versus Board of Education is a classic example. If that court had been an elected court, accountable to the voters, they would never have made that decision. They would not have had the capacity to make that decision because they would have been voted out of office, most likely. So the independence of the judiciary is critical to the preservation of our Constitution, and I would invite people to think about ways in which they can identify times or decisions when that has been key in their lives or in the life of our society. And I'd also like them to think about what it would mean to them if they had to walk into a courtroom and ask the lawyer who's representing them whether the lawyer on the other side or the client on the other side had donated to that judge's campaign, and whether they thought that meant that that judge could or couldn't be fair. That's not a position that I think people want to be in, but I don't think they really play it out or think about it. The last couple of things I would ask them to consider is becoming involved. Judicial nominating commissions, judicial performance commissions have members who are on a rotating basis. It's a wonderful position to hold. There's a huge amount of upward learning curve, but engagement, and I think people recognize how important it is. And those commissions include lay people as well as lawyers, so you need not be a lawyer to think about participating.
Well, terrific. Justice Rebecca Corliss, thank you so much for sharing your ideas about a better approach to judicial selection, retention, and informed public involvement in this process. I hope you'll join us in the future as we bring more engaging ideas from the Academy to the community. I'm Jim Grismer. Thank you for watching.